Now I'm going to give the word to Professor Samsung from the East China University of Political Science and Law, and he will talk about court reform and intellectual property protection in China. Thank you, Professor.
Thank you. Thank you for inviting me to speak for this conference. And particularly thank you to Professor Carlo Piglia and also other professors who contribute to this conference. It is a great pleasure and honor to be here. Um, my topic here is court reform and intellectual property protection in China, but actually I can say that's the topic or the core theme of this conference is focusing on ADR, but so what I'm talking about is the DR, not alternative, right? It's a DR and traditional courts system. And I think this could be a very good starting point for considering the future of disputes resolution. And I'm a professor, a law professor at East China University of Political Science and Law, and also for this moment, I also been acting as the vice president of the court of the internet in Hangzhou, which is a court. I'm also the chief justice in this court. I will talk about this quote in the following presentations. Um, Here, I've been teaching IP law in China for international students for over 10 years after completing my PhD research and postdoc research in Australia, in Brisbane, Australia. In the past, well, I'd say over 15 years, when I was talking with international friends and students about the legal system in China, and particularly to those international students who are doing a law degree in China or to do a law or course on Chinese law in China as international exchange students, they always I always try to let them understand. So why you are doing a law degree here in China? Why Chinese law matters? Whether the Chinese law is so different from those in the Western world. And here, my answer here, or put simply, um, well, I think from my perspective or from my experience, all those observations in the past over 15 years, I think, and the Chinese legal system today has no differences from those in your countries. Let's say maybe there are a little bit differences in other areas, for instance, marriage law, family law, right? But in the case of intellectual property law, contract law, and many other legal systems or legislations or areas of law, we share extensive similarities. But we are speaking different languages. You're speaking Italian, English here in Chinese, but to be honest, those core theories underlying those legislations here in China, even the core principles, the wording of the legislations will say shows such extensive similarities with those in your countries. Why? Because I think what this system here in China, in a modern China, let's say starting from the beginning of 1980s, and that's this man Deng Xiaoping introducing the so-called open the door policy in China. Right, the legal system here in China today is so different from those in 30 years ago, right? Why? Because why the legal system here has nothing to has no differences from those in European countries or in the US or other Western countries, even the Japanese legal system. Why? Because I think the core reason is that my open the door policy and the core idea of the so-called open the door policy is to introduce allowing the operation of market economy, right? And the market economy here in China, that's a key or that's a core or the key to all those problems or doubts arising from different backgrounds of nationality or culture. And when we are saying the market economy, if the entire nation, entire government is behind the market economy, I think the core political and structural political legal system and the philosophy of a legal system, or theories of all those legal systems, are all share some extensive similarities. Why? Because to me, to allow the play of a market economy, and they I think the two principles are so important. Say, number one, you have to protect, say, private property rights, right? Private property rights are all respected and protected in China. That's so different from those, say, in the so-called central planned economy, right? In that economy, there is a no recognition, no protection to private property, because the property is all owned by the state, right? You were allocating the resources, giving you the property to support your life based on your contribution to the society. But in a nation, in a society based on market economy, that's completely different picture. And so to allow the survival of a market economy, and the private properties must be protected, and also the free flow, free transfer of property must be encouraged and allowed, of course. But in 30 years ago, before they opened the door policy, and that completely different world. You even are not allowed as an individual, you are not allowed to just and sell what you own on the market in exchange for money or for other goods, right? Because you're not allowed to do so, right? Like it's not so well right today, right? But that was the philosophy at that time, but it's following the Soviet Union system. But the free flow, the free transfer of ownership, and the promotion of for trading and transfer of ownership, and also the legal system protects individuals equally under the law. Right. That's to me that's a core features of the legal system supporting so-called the market economy. What if we are still with if this society, this country is still based on the market economy, I don't see any significant differences between the legal system in China or in other foreign countries. That's my observations. And every time when I'm giving a speech or giving a lecture to international students, I'm always starting from this. So now I will be moving very quickly to the RP system here in China, use legislations in China. You will see, and why I'm starting from the legislations. You will see that those legislations um, has nothing to do with those in Western world. The trademark law, unfair competition law for the protection of commercial signs, trademarks, and the patent law of China, the copyright law of China. These are all being amended frequently, and the trademark law was amended. You see, in the most recent amendments was completely in 2019, and the unfair competition law 2019, and the patent law of China, the copyright law of China. Well, you see, if you do have have the interest in taking a look at the text of those Chinese legislations, you will say, wow, that's quite similar to those I can say from the legislations in my country or from those textbook I learned from from those professors in my own universities. But in China, the legislations here, patent law and copyright law or trademark law, they're all made by the National People's Congress. But apart from those legislations, there are extensive areas of regulations made by governments and ministries, authorities of governments. And also, in practice, the Supreme Courts of China issued a great number of judicial interpretations. The judicial interpretations has been functioning basically as legislations. That's very different practice in China because to my knowledge, I don't think any Supreme Courts in other countries would make or issue judicial interpretations which is essentially being functioning as legislation. So, well, although we don't think we're not calling this as legislation, so, but actually this national binding. And why? Because Supreme Courts and other courts and judges have been complaining that the legislation here in China is not detailed enough. They're not providing sufficient guidance for trial in the courts in specific cases. So here, all those international conventions concerning IP protection being accepted by China, and China all members of those key major international conventions. But so those laws, legislations are made by China. I say, who were the maker of law, the lawmakers? Well, you say that's a very classical picture of the government structure in Western world, right? Check and balance, the Supreme Courts, right? The executive branch and also the legislative branch. But here in China, different picture of a check and balance. Of course, the other would say, well, is that really a kind of check and balance? Of course, here you say on the Chinese law here, the basic structure is that the National People's Congress is on the top, right? The State Council, the central government, Supreme Court, and the Supreme Procurates, they're all affiliated to the National People's Congress. They all required to make reports to the National People's Congress. And so to having this picture in mind is very important for you to understand who were the one making the law and who the one enforcing the law, why, and we have some problems in reality when we're talking about a disputes resolution in reality in China with that courts in China. Why it's so difficult also requires such tremendous efforts to push and the courts to come up with results that's consistent with your expectations. The National People's Congress, let's say, the theory is that the power of the country should be in the hand of the people. So that's the top authorities making the law and a standing committee, and that's moving very quickly by the central governments. And here, what I'm trying to talk is the role of the courts. Right? You see, the courts here is not when you see the courts of here, the place of courts here in China, and is not the picture you can see in many other Western countries, right? The check and balance system. But here, in the Chinese political system, the courts and the presidents of the courts, they're all required to make reports to National People's Congress. For local courts, they have to make reports to the local National People's Congress, local People's Congress. And this court structure, over here, we have the 4 levels and 2 instances. We have 1 Supreme Court and a high courts for each province, which is around 30, and the intermediate courts, and the basic people's courts as a county level, district courts. And so this another very important picture to understand the disputes resolution mechanism in China. And usually it means 2 system means you only have 1 chance to appear, right? If the courts for the first trial is intermediate courts, and then you would need to appear to the high courts here. But if the courts for the first instance is the basic courts here, and then you would have to appear to the intermediate court, right? So, but that system being significantly reformed and from 2014 the case of IP adjudication. Why? Because you see, if there were legislations and those wordings and theories behind those legislations shares such extensive similarities with those in Western world, why to many of you, you may say, well, why, how can that be? In reality, people would have different feelings, right? Why, well, someone would argue that, so, well, very similar disputes coming up with different results. And that's make it quite confusing to some international companies. So the point here is that the law is over here, but the who were the one enforcing the law would also be very important. And the problem with RP trial is there are so many basic codes, and the cases concerning or relating to intellectual property usually will be so complicated, and then that's make it a very difficult for the judges in local courts to unify the application of legislations, and also the courts for the second trial, um, there any courts except the basic courts could be the courts for second trial, right? The intermediate courts, high court and supreme courts, they will all have opportunities to be the courts for second instance. So here the reform, the idea is that, so, well, how about in the case of IP disputes, we have a special articles and to exercise jurisdictions over intellectual property issues. And then there will be only one court to hear appeal. So which means the decisions or judgments delivered by the IP courts would be appealed to the Supreme Court directly. In that case, it significantly change the application of legislations in reality. So unify the application of legislations, and because the Chinese law, you say, it's quite difficult for you to be a judge in China because you say, for instance, the U.S. copyright law, you say how many pages? If you print it out, it's over 500 pages. But how many pages of Chinese law you printed out? It's around 10 pages. Can you imagine that the U.S. copyright law 500 pages, but the Chinese copyright law only 10 pages? How can the courts in reality to apply a copyright law which is only 10 pages, right? So it's so important for the courts, for the judges to unify their understanding of an application of legislations in China. And that's from 2014, we have in Beijing, Shanghai and Guangzhou, we have the special courts to handle RP case. And in the Supreme Court, it also creates a separate one to handle any case appeared from intermediate courts and other courts delivered by and other decisions delivered by the Supreme Court. And here I'm the vice president of the Hangzhou Courts of the Internet, so which is a course. You say, why the courts of internet? What does that mean? I think that's quite interesting creation in China. I'm not sure whether you have this in Italy or ever have any discussions in this. But the idea is that, well, today we have internet. So why we have to make those people to come to the courts, traveling hours to be seated in the courtroom to solve their disputes? Why we cannot just make a phone call or just have video call, right? We have everything solved. And so, sorry, I would have maybe I would need another 2 minutes. Would that be okay? Yeah. So here, the internet courts basically say anyone can file disputes online, and the entire trial proceedings would all be completed online. And then the court opinions delivered by these courts will be enforced automatically. And also, if, for instance, if you order a product from Taobao.com or other e-commerce platform in China, having any disputes with the sellers in China, you can sue those guys via these courts. And you don't have to come to China to be seated in a courtroom, and then the problem will be solved. So that's we even have an English version of the entire filing system online. So you may, if you're interested, you may just click on this. Try to visit this website to see how it works. Well, you see why I think this is quite relevant to the topic of this conference, right? Your topic is focusing on ADR, but this DR, or traditional dispute resolution, the court system, right? We are trying to reform the distribution mechanism in China to making it be updated with the evolution of technology and the economy and the governance of society. And this reform basically is like well, the courts should not be limited to specific jurisdictions, right, to handle cases arising from that area. So, and in the future, the idea could be that anyone, and the courts will be functioning as arbitrator, right? Basically as an arbitrating committee. And anyone who are happy with this courts in Shanghai can file a case with that court in Shanghai online and get the problem solved and get the judgments enforced online automatically. And this system being connected to also to the major e-commerce platform and also the banking system here in China. And you see, the idea in the future could be that, say, the courts in China could be that could be only, well, let's say over 20 courts in China, and you can sue someone or file a case where you can pick up any courts. You say, well, I'm happy with that court, and that court can I'm happy with their efficiency, their reputation, and their experience, their expertise. So I pick up that court. So this is very interesting. Well, that's very similar to the concept of ADR, right? You're talking about arbitration and mediation, right? And people can pick up any venue, any arbitration committee to handle this case, right? But here the concept in the future here will be that is also be applicable in the court system. Well, but there are also differences between the court system and the ADR, right? Mediation and arbitration. Why? Because the we're not the awards delivered by our arbitrator would have to be enforced, right, by the court and also subject to judicial review. But the court system, the judgments delivered by these courts is not subject to judicial review because there's a judicial outcome, right? And it can be appealed, of course, to a higher courts. And so when we are talking about the future of disputes resolution and reform of courts here, we've been thinking or been pushing by the evolution of economy and the developments of digital economy and the e-commerce platform. And the society being evolving quickly, and the people they don't want to be stuck with the old court system. It's so costly. It's so not efficient. I'm not sure how can this be related to your topic here, right? The ADRs and the future of ADR. And just maybe it's just a starting point. And thank you all. That's all my presentation. Not sure how much, over 20 minutes already, right? Sorry for that. And that's my email, right? Samsung@outlook.com. If you do have any further inquiries or interest to or information to share with me, you're of course highly welcome to let me know.
Thank you, Professor
Okay, thank you. Thank
Samsung.
you.
Thank you.